A very good evening to all of you friends. A very good evening to all of you. Welcome to BYJU'S exam prep. So friends, today I am going to discuss with you a very important judgment that was delivered by the Punjab and the Haryana High Court just 2 days back. Now, what is this judgment? I know that most of you are aware of it, but those of you who are also aware of it must know that how important is this particular judgment insofar as understanding certain very important concept relating to the Indian Constitution is concerned, relating to fundamental rights, the power of the state legislature, and the concept of reservation. So today I'm going to discuss with you a very important and a significant judgment that has been laid down by the Punjab and the Haryana High Court relating to domicile reservation in private sector jobs. Now, the government of Haryana, or the state legislature of Haryana, created a particular law whereby it said that they are going to provide 75% reservation in the private sector jobs only to people who are domiciled in Punjab and Haryana. Sorry, in Haryana. So the Haryana government decides to make a law relating to the provision of providing 75% domicile reservation in Haryana private sector job. 75% of the private sector job would be reserved only to people of Haryana in Haryana. Now, that particular law was challenged in the Punjab and the Haryana High Court, and finally 2 days back the Punjab and the Haryana High Court decided that this particular law is unconstitutional. So let's look at the law first, and so that you get a better understanding of what is the judgment. Now, way back in 2020, around 3 years back, 2020, the Haryana legislature passed a particular law which is known as the Haryana State Employment of Local Candidates Act of 2020. So the Haryana legislature passed this particular law whereby this particular law provides 75% reservation in private jobs for people who are domiciled in Haryana. Now, what is the objective of the act? Now, the objective of the act simply says that there is a huge amount of migrant people who are coming in the low-paying jobs in Haryana, which is creating a significant impact, especially local infrastructure and housing. So, why is this particular law created? Because at the background, you must remember this particular law is created for the purpose that, there is a large number of migrant workers coming in Haryana, and the locals of Haryana are unemployed. There is a huge amount of unemployment insofar as the people belonging to Haryana is concerned. So people from all across India is coming to Haryana, especially now you have Gurgaon, okay? Yeah, and that is a huge and significant market. All the big MNCs and all these big companies are all have their offices in Haryana, that is Gurgaon. Now, what has happened is, because of huge amount of people from across India coming and working in Gurgaon and other places, the locals are losing the jobs. The locals. That is the concern of the legislature. And it further says, therefore, giving preference to local candidates insofar as low-paying jobs are concerned is socially, economically, and environmentally desirable. And it is in the interest of the general public. So here is a particular law that was created by the legislature of Haryana. Now let's understand the scope of this act. Now the scope of the act is, the scope is limited. The applicability of this act is limited to those people who are earning up to 30,000 rupees a month. So people above 30,000 rupees, there is no reservation. Only people in the low paying capacity, okay, 5,000, 10,000, 20,000, 30,000, till 30,000, if your gross monthly salary is 30,000 or your wage is 30,000 per month, then you come within that scope. Now, secondly, this law is not only applicable to the government sphere, it is applicable to where? Please understand this. It is applicable to private sector. Now that's very, very important. It is applicable to the private sector companies, societies, trust, limited liability partnership firms, partnership firms, any person who employed 10 or more people on salary, wages, or other remuneration. That means the manufacturing unit. So here is a particular law that differentiates between those who are domiciled in Haryana and who do not have a domicile in Haryana. Is that clear? Now, what are the grounds for challenge? The grounds for challenge are, it effectively provides a scope of reservation. Now, you are providing 75% reservation to the domiciles of Haryana in private sector. So this is a kind of reservation, right? So that's the first scope of challenge, that, this law is under the garb of a reservation policy. Secondly, it violates the fundamental rights of private employers to carry their business and trade. Now, every person has a right under Article 19 of the Indian Constitution to carry out any trade, business, or commerce. Now, if there are restrictions on the employer to choose their employee, is it a restriction or not? मैं एम्प्लॉयर हूं, मेरे को एक कंपनी खोलना है, मेरे को उसका हेड ऑफिस गुड़गांव है. अब क्या हो गया है, मेरे को 75% लोग जो मैं रखूंगा मेरा कंपनी में, 75% लोगों को हरियाणा के होना चाहिए. Now, is it not a kind of restriction on my freedom to trade, freedom of business, freedom to commerce? Yes, it is. Thirdly, it was challenged on the ground that it is contrary to the principles of justice, equality, liberty, fraternity as laid down in the preamble to the Constitution. Now, the Constitution deals with, India, I'll give you this example. Do we have, okay, I am from West Bengal. So do I have a citizenship of West Bengal, or am I a citizen of the country? I'm a citizen of India. I have a right to work anywhere, maybe Bangalore, Mumbai, Delhi, any part of the country. I have a right to work. Now, if these kind of laws starts coming, then, you cannot work anywhere else on earth. So tomorrow, West Bengal government will come up with this particular law, says that, okay, 75% reservations in private jobs for West Bengal people. Okay, Maharashtra will come with some law like this. Bihar will come with some similar law like this. Uttar Pradesh will come with similar law like this. Then what happens? You are restricted within your own territory. I cannot work in Delhi. Delhi legislature will also come up with something similar like that. Then what happens? The problem is there. The problem lies over there. कि हर स्टेट एक एक खुद का एक कानून लाएगा कल और बोल देगा कि अरे नहीं, सिर्फ मेरे ही लोग को, मेरे स्टेट में जो डोमिसाइल है वही काम कर पाएगा. नहीं, ऐसे करेंगे तो the India will get divided. India will get divided. Is that clear? Is that clear, everyone? Okay. Okay. Fourthly, it was one of the ground of challenge was it is contrary to the right to equality as enshrined under Article 14 and 19 of the Indian Constitution. And it creates difference between people domiciled in different state, which is contrary to the concept of common citizenship provided under the Constitution. Now, if tomorrow every state in India comes with similar laws, what happens? Then the country gets divided. A person from Bihar won't get a job in Maharashtra. A person from Maharashtra won't get a job in Karnataka. A person from Karnataka will not get a job in Himachal Pradesh. A person from Himachal Pradesh will not get a job in Delhi. That will create an absurdity if this continues. And that is why, and that was one of the reasons the Punjab and the Haryana High Court has struck down this entire legislation of the Haryana government. Now, before I move on to the judgment, what did the judges say? BYJU'S Exam Prep brings to you ACE CLAT with BYJU'S Exam Prep. Unlock your 3-day free trial access today. Go to the description box below. You will find the link out there. Now, what did the court say? The court very categorically stated certain very, very important things. It stated that it is not for the state as such to direct private employers who it has to employ, keeping in view the principles of laissez-faire. That means the lesser it governs, the better itself. Once there is a bar under the Constitution of India, we do not see any reason how the state can force a private employer. State कैसे एक private employer को force कर सकते हो कि आप local candidates को ही लोगे employment में? It is not for the state to. Now, I am a company. I will choose किसको मैं मेरा कंपनी में रखूंगा, किसको नहीं रखूंगा. तो एक मैं प्राइवेट कंपनी हूं, मैं गवर्नमेंट का कंपनी नहीं हूं, मैं प्राइवेट एम्प्लॉयर हूं. Can I be forced that okay, no, you have to take people from Haryana, you have to take people from Delhi, you have to take people from Maharashtra? No, it's my choice. I have a freedom to choose my employees. That is what the Punjab and the Haryana High Court, the division bench, said. That it is not for the state to force a private employer to employ a local candidate, as it would lead to large-scale state enactments. Now, that is what is the concern. That is what I was saying. The judgment says that if Haryana does it, tomorrow Punjab will do it. Day after tomorrow, Delhi does it. Day after that day, Uttar Pradesh does it, Tamil Nadu does it, Andhra Pradesh does it, Bihar, West Bengal, Odisha, every state are going to do all these kind of things, these kind of laws. And this will provide what? A protection to its resident. This will create artificial walls throughout the country, which the framers of the Constitution had never envisaged. You are creating artificial walls throughout the country. Is that clear? Is that clear, everyone? सभी को समझ में आ रहा है? Every one of you? Okay, that's good. So guys, it's a very, very important thing. Just, yeah. Okay, good. Then, the court also said that private employer has been put under the anvil of the state as to whom to employ and the penalties which are liable to be imposed on contravention, which have already been noticed, which multiply on account of any violation, apart from leading to criminal prosecution by filing a complaint. the state continues to exercise absolute control over private employer, and as noticed, directing it to do which itself is forbidden for public employment. In such circumstances, we are of the considered opinion that the restriction imposed by the statute has far-reaching effects and cannot be held to be reasonable. Because one of the argument of the government for upholding this particular enactment was that, the restriction is a reasonable restriction. None of your fundamental rights are absolute. They are all subjected to reasonable restrictions. Now, that reasonable restriction argument has been demolished by the judgment, says that this is not a reasonable restriction. And this requires the court to interfere with this particular law. The court also said that we are of the opinion that it is beyond the purview of the state to legislate on the issue and restrict the private employer from recruiting from the open market for the category of employees. So here is this court saying that it is beyond the authority of the state legislature to make a particular law like this. It is not for the state to make laws like this which are going to create artificial boundaries within the country. You cannot do that. Is that clear? And finally, the court said that we are of the considered opinion that the writ petitions are liable to be allowed. The Haryana State Employment of Local Candidates Act 2020 is held to be unconstitutional, violative of your fundamental rights under Part 3 of the Constitution, and is accordingly held ultra vires the same and is ineffective from the date it came into force. So, from the date this particular law came into force, it has been struck down. So finally, the Punjab and the Haryana High Court, a division bench of the Punjab and the Haryana High Court, has struck down this contentious law, this very controversial law, which dealt with providing 75% reservation in Haryana for the domiciles of the people of Haryana in private jobs. And the applicability was people whose salary or their remuneration or their wages is up to 30,000 rupees a month. Is that clear? Any questions, any doubts? So those of you who will be watching the recorded session, requesting all of you that in case you guys have any doubts, any confusion, you can definitely give your ask the questions in the comment section after the video is over, and I'll get back to you. Okay, fantastic. Okay, so guys, if you're liking this session, do press the like button. Those of you who are preparing for CLAT 2025, BYJU'S Exam Prep brings to you CLAT 2025 comprehensive course. 380 hours of live classes, 300 recorded videos, 55 mock tests, 10,000 plus practice question, practice tests, study material, doubt resolution, and the CLAT Ignite magazine. So guys, do subscribe to our YouTube channel if you haven't by now. I'm sure that most of you have already. Do follow us on Instagram, like our Facebook page, join our Telegram channel, and do not forget to download the BYJU'S Exam Prep app today. With this, we come to the end of this session. Thank you very, very much. I hope you understood this particular landmark judgment. I'm sure that this judgment will be challenged in the Supreme Court of India someday or the other, very soon, might be. And we have to then wait for the Supreme Court for its decision about this topic. But as of now, this particular judgment, which is given by the Punjab and the Haryana High Court, unless it is changed by the Supreme Court, is final. Okay. Thank you very, very much. God bless you. Bye-bye. Take care. Good night. Thank you.